Every law you've ever heard of was written because something went wrong. These 31 weren't written by philosophers. They were written by investigators standing over bodies, asking how this happened again. 1. You've been told your entire life that the FBI's DNA database, CODIS, was built as a proactive triumph of modern science, a forward-thinking system designed before the crisis arrived. That is exactly backward. The DNA Identification Act of 1994 exists because fingerprints, the tool everyone trusted, repeatedly failed to connect serial killers who were operating across multiple jurisdictions for years. Gary Ridgway murdered at least 49 women in Washington state across roughly 2 decades. Fingerprint evidence collected at early scenes was insufficient to build a case. A DNA sample taken in 1987 was eventually matched to Ridgway in 2001, 14 years after it was collected, sitting in storage while he continued killing. The technology to run the match existed. The legal mandate forcing anyone to run it did not. Before CODIS, individual state crime labs operated in complete isolation. A killer arrested in one state was not routinely checked against unsolved homicides in neighboring states. There was no mechanism forcing that comparison. The original CODIS database launched with profiles from convicted sex offenders specifically because legislative advocates argued those offenders had the highest documented rate of escalating to homicide. A direct rhetorical response to cases where predators had prior records that nobody had connected. As of the most recent figures, CODIS contains over 20 million offender profiles. But the law requiring states to upload those profiles was fought bitterly and implemented unevenly for nearly a decade after passage, because states resented the federal mandate telling them how to run their crime labs. The United Kingdom's equivalent system, the National DNA Database, was built 1 year after CODIS, explicitly modeled on the lesson that local fingerprint databases are jurisdictionally blind. Britain watched American serial killer cases fail and decided to build something different. The automated fingerprint identification system wasn't nationally integrated in the United States until 1999, meaning serial killers had a roughly 25-year window in which fingerprint evidence in one county was physically incapable of being matched to fingerprint evidence in another without a human examiner, a physical card, and someone who already knew to look. Trusting fingerprint cards in separate filing cabinets to catch a mobile serial killer is like trying to find a thief using only the left half of a security camera. The evidence existed. The law just hadn't required anyone to look at the whole picture yet. 2. Most people assume Miranda warnings. You have the right to remain silent. You have the right to an attorney. Are some ancient, self-evident cornerstone of justice that reasonable people always agreed upon. A bedrock principle that was obviously always there. It was not. Miranda v. Arizona, decided in 1966, was a legal explosion triggered by documented cases of police extracting confessions through psychological coercion in rooms with no oversight from people who had no idea they could refuse to speak. And while those confessions were being extracted from the wrong people, actual killers were watching. Ernesto Miranda himself was convicted of kidnapping and rape, not murder. The Supreme Court used his case as the vehicle precisely because his interrogation perfectly illustrated a confession obtained without any awareness of rights, a technique that had also contaminated numerous homicide investigations by locking in the wrong suspect and closing the case file. In the years before Miranda, wrongful convictions in murder cases were overturned after it emerged that confessions had been produced through sleep deprivation, extended isolation, and outright deception. These were standard approved police tactics. The psychological interrogation manual, most commonly used by American police in that era, the Reed technique, was specifically engineered to produce confessions. Later studies showed it generated false confessions at statistically significant rates, particularly under the pressure of a homicide interrogation, where the emotional stakes were highest. The Miranda decision itself was 5-4. 4 Supreme Court justices believed the ruling would catastrophically damage law enforcement's ability to solve violent crime. The dissent explicitly cited homicide clearance rates. After the decision, those rates did temporarily decline in several major cities, and opponents cited those numbers for years afterward. What those statistics obscured was that a significant portion of previously cleared cases had been closed, using confessions that would not have survived post-Miranda scrutiny. The cases were solved on paper. The killers were sometimes still free. Today, the right to counsel during interrogation exists in no small part because false confessions in murder cases, including cases tied to active serial killer investigations, demonstrated that an unmonitored interrogation room was as dangerous to justice as it was to the person sitting in the chair. Every word of that warning is a specific injury to a specific innocent person in a specific room before someone finally said enough was enough. 3. Most people assume sex offender registries are an obvious, long-standing feature of the legal system. Common sense policy that surely existed long before anyone had to fight for it. Public notification laws for convicted sex offenders did not exist in the United States before 1994. Before Megan's Law, police departments routinely knew the home addresses of convicted child predators and had zero legal obligation to tell the surrounding community a single word about who was living next door. On July 29, 1994, 7-year-old Megan Conca was raped and murdered in Hamilton Township, New Jersey, by Jesse Timmendequis, a twice-convicted sex offender who had moved directly across the street from the Conca family. Local police knew his history. The family knew absolutely nothing. Timmendequis had 2 prior convictions for offenses against children. He had served his time, been released under standard parole supervision, and relocated to a residential neighborhood where his background was confidential law enforcement information. New Jersey passed Megan's Law within 89 days of her murder, one of the fastest legislative responses to a single criminal act in American state history, driven entirely by the public's fury at learning the system had deliberately kept the neighborhood uninformed. The federal version, the Jacob Wetterling Crimes Against Children and Sexually Violent Offender Registration Act of 1994, had passed the same year but contained no public notification requirement. It only mandated registration with police. Megan's Law, passed in 1996, amended it to require community notification, a legally significant distinction that took 2 more years and 1 more murdered child to produce. Before these laws, individual states kept internal registries used only by law enforcement. The registries were confidential tools. The philosophical position of the pre-1994 era was that public disclosure violated offenders' privacy rights, and courts repeatedly upheld that position. The implementation of public registries was immediately challenged on constitutional grounds. The Supreme Court upheld the laws in 2003, ruling that registration was regulatory rather than punitive. The gap between police knowing and the community knowing proved lethal in multiple documented cases beyond Megan Conca. Investigators reviewing similar situations post-1994 identified numerous instances where registered offenders had reoffended while living invisibly in communities that had no awareness of their background. A system that registers a predator's address and then locks the file in a police drawer isn't protecting children. It's protecting paperwork. 4. Most people assume that obsessively following someone, showing up at their home repeatedly, and turning their life into a sustained campaign of terror was always criminal. Surely that was obviously illegal. The United States had no criminal stalking statutes until 1990. Before that year, police responding to harassment complaints could do nothing unless the perpetrator made an explicit verbal threat or committed a physical assault, showing up every day, every week, for months. Perfectly legal. On July 18, 1989, actress Rebecca Schaeffer was shot and killed at her apartment door in Los Angeles by Robert John Bardo, a 19-year-old obsessive fan who had spent years sending letters and attempting to reach her. He obtained her home address through a private investigator who accessed California Department of Motor Vehicles records legally. Bardo had previously attempted to gain access to Schaefer's studio on multiple occasions. Security had turned him away and flagged him as a concern. None of it met the legal threshold for arrest because he had made no explicit criminal threat. Everything he had done was, technically, not a crime. California passed the first anti-stalking law in the United States in 1990, directly in response to Schaefer's murder, and several other cases in Los Angeles during the same period. Within 3 years, every other state in the country had enacted similar legislation. The original California statute defined stalking as willfully, maliciously, and repeatedly following or harassing another person with a credible threat. Deliberately narrow language engineered to survive First Amendment challenges about criminalizing behavior that stopped short of explicit threats. Bardo's case also produced California's law restricting access to motor vehicle records. He had paid $250 to a private investigator who legally obtained Schaefer's address from public records. That specific loophole was closed by statute within 1 year of her death. The Federal Interstate Stalking Punishment and Prevention Act followed in 1996 because state-only laws created gaps when stalkers crossed state lines, a documented problem where restraining orders issued in one state were unenforceable in another. Before 1990, police responding to stalking situations were legally limited to suggesting victims change their locks, move, or obtain a civil restraining order that carried no criminal penalty unless violated, and which, in multiple documented cases, the stalker violated immediately after being served with no legal consequence. Rebecca Schaefer is the reason the phrase, terrifying but technically legal, no longer ends the conversation. 5. The public believes the FBI's criminal profiling methodology emerged from rigorous academic research, peer-reviewed science, and systematic study. A serious, validated discipline that lets investigators reliably predict offender characteristics from a crime scene. The foundation of the FBI's Behavioral Science Unit was built primarily on informal interviews with 36 convicted killers, conducted with no control group, no peer review, and no standardized methodology by agents who were simultaneously developing law enforcement policy based on those same interviews in real time. Agents Robert Ressler and John Douglas conducted their foundational interviews with killers, including Ted Bundy, John Wayne Gacy, David Berkowitz, and Charles Manson between 1977 and 1983. The interviews were voluntary and unstructured, based entirely on whatever the subjects chose to reveal. The resulting typology, organized versus disorganized killers, became the cornerstone of FBI profiling training and was incorporated into investigations nationwide without ever being subjected to peer-reviewed validation. It was published in the FBI Law Enforcement Bulletin in 1980 as established doctrine. A 2007 review published in the Journal of Police and Criminal Psychology examined 130 published studies on criminal profiling and concluded that profilers performed only marginally better than non-profilers on crime scene assessments, and in some categories performed worse than experienced detectives who had no profiling training at all. The Violence Criminal Apprehension Program, enacted into law as part of the Justice Assistance Act of 1984, was the legislative product of this work. It created a national database for linking violent crime patterns, a genuinely useful tool. The profiling methodology that justified its creation, however, remained scientifically contested from the beginning. Douglas has acknowledged in his own published accounts that the 36 killer study used a self-selected sample, killers who agreed to participate, which systematically excluded the most pathological offenders who refused, potentially the ones with the least self-awareness and the most distorted reasoning. The FBI profiling method was deployed prominently during the Beltway sniper investigation in 2002. The profile described a single white male acting alone. John Allen Muhammad and Lee Boyd Malvo were arrested. The profile was wrong on every significant characteristic. The system that trained generations of investigators to read a crime scene like a psychological map was itself built without a map. It produced federal legislation first, and peer review never. 6. People assume that a missing child has always triggered an immediate, coordinated emergency response. That the 24-hour waiting rule was always a myth. That police always mobilized from the first minute. The 24-hour waiting rule was standard enforced policy in the United States well into the 1980s. The National Center for Missing and Exploited Children was created in 1984, specifically because the existing system had allowed children to be murdered during a mandatory waiting period that existed for bureaucratic convenience, not any legitimate investigative reason. Adam Walsh was 6 years old when he was abducted from a department store in Hollywood, Florida on July 27, 1981. His severed head was found 2 weeks later. His father, John Walsh, confirmed that early in the investigation, police were slow to mobilize a coordinated search and treated the family with suspicion during the initial hours. Eaton Patz disappeared in New York City in 1979, becoming one of the first missing children to appear on a milk carton. A public distribution campaign born entirely from the recognition that law enforcement had no national mechanism for circulating descriptions of missing children. The milk carton program existed because the system had nothing equivalent. The Missing Children Act of 1982 and the Missing Children's Assistance Act of 1984 were passed back to back, specifically to force the FBI to enter missing children's cases into the National Crime Information Center, something the Bureau had previously refused to do, classifying child abductions as primarily local matters outside their operational scope. Before these laws, the FBI's position was that abductions were a local responsibility unless there was evidence of interstate transport. This meant federal resources were withheld precisely during the window when they were most critical. The 24-hour rule had no statutory basis. It was informal policy developed because departments used missing persons reports as a proxy for runaways, assuming most disappearances were voluntary. Studies conducted after the rule was largely abandoned showed the greatest danger to an abducted child occurs within the first 3 hours. The Amber Alert system, formalized into federal law in 2003, is named for Amber Hagerman, a 9-year-old abducted and murdered in Texas in 1996. Another case where the absence of an immediate public broadcast was cited as a factor in the outcome. The law treating a missing child as an emergency rather than a scheduling problem wasn't a moral awakening. It was a body count reaching a threshold that legislators could no longer explain at a press conference. 7. People believe the insanity defense is a reliable escape hatch that manipulative killers routinely exploit, and that the legal system has always been either naive about this or powerless to stop it. Ted Bundy, while representing himself during his Florida trials in 1979, provided investigators and legislators with an intimate operational demonstration of exactly how an intelligent defendant attempts to manipulate competency proceedings, court delays, and the court's obligation to accommodate a self-representing defendant. The reforms that followed were written in direct response to his specific documented tactics. Bundy waived his right to counsel and represented himself, a decision widely analyzed as a calculated strategy to create procedural delays, control media access, and exploit the procedural machinery available to pro-se defendants. He filed more than 30 motions during the Chi Omega murder trial, many of which legal scholars described as technically sophisticated for someone without formal legal training, evidence that a sufficiently intelligent defendant could weaponize courtroom procedure to extend proceedings almost indefinitely. Florida subsequently tightened its laws around self-representation in capital cases, making it significantly harder for defendants to delay trials through serial competency challenges and pro-issue status, a direct legislative response to documented patterns in the Bundy proceedings. The Insanity Defense Reform Act of 1984 was passed by Congress partly in response to the acquittal of John Hinckley Jr. in the Reagan assassination attempt, but was also shaped by academic work conducted on serial killer psychology in the post-Bundy era. The act narrowed the federal insanity defense and shifted the burden of proof to the defendant, a structural change that made the defense substantially harder to mount. Bundy's execution came in 1989, after an extraordinary decade of appeals, competency hearings, and procedural motions, a timeline that several state legislators explicitly cited when pushing for reforms to death penalty appeal processes in Florida and neighboring states. Multiple states passed reforms to competency evaluation procedures in the 1980s, specifically to prevent defendants from manufacturing psychiatric symptoms to delay capital proceedings. Kenneth Bianchi's claim of multiple personality disorder during the Hillside Strangler case, later exposed as fabricated through forensic psychological testing, accelerated professional and legislative efforts to standardize competency evaluation standards across jurisdictions. Bundy spent a decade showing the courts exactly how a brilliant, manipulative defendant could play the procedural mechanisms of a trial like an instrument. The legislators who followed took notes and methodically removed the keys. 8. The legal framework governing electronic surveillance is assumed to be a pure civil liberties achievement. Privacy advocates winning protections against government overreach, with law enforcement grudgingly accepting limits as the cost of living in a free society. While civil liberties concerns were real, the Electronic Communications Privacy Act of 1986 and the surveillance reforms that followed were also intensely shaped by documented failures in serial killer investigations. Failures caused by the gap between the speed at which killers adopted new communication tools and the speed at which warrant processes could legally authorize monitoring those communications. John Edward Robinson, sometimes identified as the first known killer to use the internet to find victims, recruited women through early online platforms throughout the 1990s, while investigators faced legal delays in obtaining the communications evidence that could have identified him earlier. The Electronic Communications Privacy Act created a 3-tier warrant system for different types of electronic data. Law enforcement lobbied intensely during drafting to ensure that certain categories of metadata, location data, communication logs, could be obtained without a full probable cause warrant, specifically citing active violent crime investigations as the justification for the carve-out. The Patriot Act of 2001, while framed primarily around national security, contained provisions that dramatically expanded law enforcement access to electronic records in serial violent crime investigations. Provisions the FBI had sought for years before a political opening made them achievable. Dennis Rader, the BTK killer, was caught in 2005, partly through metadata recovered from a floppy disk he sent to investigators, a method his defense later argued should have required a warrant. The case raised unresolved questions about digital forensics and warrant requirements that filtered into subsequent case law and are still being litigated today. The Golden State Killer, Joseph James DeAngelo, was identified in 2018 through genealogical DNA databases, a method that existed in a complete legal gray zone. No law authorized it. No law prohibited it. Congress subsequently held hearings that produced proposed legislation directly addressing the gap, citing the DeAngelo case by name. Law enforcement agencies have repeatedly used documented serial killer investigations as legislative leverage to expand electronic surveillance authority, creating a pattern where the frameworks nominally designed to protect everyone's privacy are carved specifically by the operational needs of homicide investigation. Privacy law and serial murder investigation have been negotiating with each other for 40 years. Every time a killer uses a new tool to find victims, another carve-out appears. 9. People trust that crime lab evidence in serial killer trials is produced by rigorous, accredited science. that results are reliable, analysts are independent, and the chain of custody is airtight. The forensic standards governing American crime labs were substantially reformed after a series of well-documented institutional failures demonstrated that labs had falsified, contaminated, and misrepresented evidence in multiple high-profile violent crime cases, including cases where the integrity of the evidence was the only thing standing between a conviction and an acquittal. The Houston Crime Lab scandal, fully exposed between 2002 and 2006, involved the discovery that the lab's DNA section had stored evidence improperly, produced unreliable results, and in some cases presented testimony that misrepresented statistical findings in capital cases. Over 350 cases were eventually retested, including multiple homicide convictions. Fred Zane, a serologist who worked for the West Virginia State Police and later for a Texas medical examiner's office, fabricated evidence in an estimated 180 cases over more than a decade before being exposed in 1993. Post-conviction reviews identified multiple people who had been wrongfully convicted, partly on fabricated serology in cases involving violent sexual homicide. The National Academy of Sciences released a landmark report in 2009 concluding that, with the exception of nuclear DNA analysis, no forensic discipline had been rigorously validated through scientific testing, including hair analysis, bite mark comparison, and blood spatter interpretation, all of which had been used to convict killers. Hair microscopy evidence, used extensively through the 1980s and 90s, was found to be so unreliable that the FBI conducted a review of 2,500 cases in 2015. In 342 examined cases where FBI examiners had testified, 95% contained flawed testimony overstating the significance of hair evidence. The Innocence Project identified flawed or fraudulent forensic evidence as a contributing factor in approximately 45% of wrongful conviction cases, a finding that became a primary driver of legislative reforms to crime lab accreditation. Federal provisions through the Justice for All Act mandated accreditation standards and evidence preservation requirements that had never previously existed as federal law, created specifically in response to documented forensic failure in violent crime cases. The rigorous forensic science you see dramatized on television was mostly built after the system admitted it had been inventing conclusions. The serial killer cases weren't just cautionary tales. They were the quality control audit that nobody had bothered to run. 10. Most people assume that crime victims have always had formal rights during prosecution. The right to be notified, to speak at sentencing, to be kept informed. That this is ancient, self-evident justice baked into the system from the beginning. Before the mid-1970s, crime victims in American courts had no formal legal rights whatsoever. They were classified as witnesses, potential evidence, not parties. The families of serial killer victims were routinely excluded from proceedings, denied information about their loved ones' cases, and had no legal standing to address the court at sentencing. Frank Carrington, often called the father of the victims' rights movement, founded the Victims Assistance Legal Organization in 1975, explicitly citing the treatment of homicide victims' families in the criminal justice system as his animating grievance. The President's Task Force on Victims of Crime, convened in 1982, documented in its final report that crime victims had no legal standing in criminal proceedings, were frequently not notified of hearings, and were routinely excluded from courtrooms during trial. Findings presented as though describing a new discovery, not a 200-year-old design flaw. The Victim and Witness Protection Act of 1982 was the first federal legislation to formally establish victim rights in federal criminal cases, passed 206 years after the Republic's founding. It required federal prosecutors to consider victim impact in plea agreements, a provision that had never previously existed in any form. The families of Ted Bundy's victims, many of whom had spent years not knowing whether their daughters were among his confirmed dead, were publicly vocal about being excluded from investigative information during his trials. Florida's early adoption of victim notification requirements was directly shaped by that documented exclusion. The Violent Crime Control and Law Enforcement Act of 1994 embedded victim rights into the federal criminal code, including the right to be present at trial, to be heard at sentencing, and to receive restitution, framed in congressional testimony using the explicit accounts of serial killer victims' families. A proposed constitutional amendment for victims' rights has been introduced in Congress repeatedly since 1996, with supporters consistently citing families who sat in courthouse hallways while their daughters' murders were adjudicated inside. For most of American legal history, you could be the mother of a serial killer's victim and have less formal standing in that courtroom than the killer's attorney. The laws that changed that were written in grief, and they arrived 2 centuries late. 11. People assume that laws preventing convicted killers from profiting off their crimes, selling books, licensing stories, doing interviews, have always existed as obvious common sense. That no reasonable society would have permitted a murderer to become a millionaire from the act of murder. There were no laws preventing that outcome until after David Berkowitz, who murdered 6 people and wounded 7 others in New York City between 1976 and 1977, was found to have negotiated a publishing deal while awaiting trial. New York passed the first Son of Sam law the following year. Most states had nothing equivalent for another decade. New York enacted Executive Law Section 632A in 1978, requiring that funds paid to a convicted criminal for accounts of their crime be deposited into an escrow account and made available to victims or their families for 5 years. It was the first statute of its kind anywhere in the United States. The New York law was challenged and struck down by the Supreme Court in Simon & Schuster, Inkers Verschers, members of the New York State Crime Victims Board in 1991 on First Amendment grounds. The court ruled that the law constituted content-based discrimination against speech because it specifically targeted expression about crimes and therefore violated the First Amendment. That ruling sent states back to their legislatures to rewrite Son of Sam laws that focused on unjust enrichment rather than the subject matter of speech, an attempt to thread a constitutional needle that states have been rethreading ever since. Henry Lee Lucas, a killer who confessed to hundreds of murders, became the subject of a feature film, and Texas's Son of Sam provisions were cited in disputes over whether Lucas or his estate could receive compensation related to productions based on his crimes. The issue resurfaced with the O.J. Simpson civil judgment, and again as true crime became a dominant entertainment genre, with some convicted individuals signing media deals through corporate structures specifically designed to obscure their financial interest and circumvent state statutes. As of the most recent surveys, approximately 40 states have enacted some version of Son of Sam legislation, with widely varying coverage of book deals, streaming rights, and licensing arrangements. The patchwork means a killer in one state can legally profit from actions that would be barred in a neighboring state. For one window in 1977, a man who murdered 6 people was closer to a publishing contract than most authors with finished manuscripts. The law that stopped it lasted 13 years. 12. People believe that bias-motivated violence, crimes targeting people because of race, religion, or sexual orientation, has always been recognized as a distinct category of offense requiring enhanced prosecution tools. Federal hate crime law did not cover sexual orientation until 2009. For decades, documented patterns of violence targeting gay men specifically, including cases involving serial predation, organized targeting, and repeat offending, were prosecuted, when prosecuted at all, as ordinary homicides with no legal mechanism to capture the pattern or the motive that drove it. Jeffrey Dahmer murdered 17 men and boys between 1978 and 1991. Milwaukee investigators later acknowledged that at least 2 of his victims had been encountered by police in circumstances that should have prompted intervention and were instead returned to him. Community advocates subsequently linked that failure to the systematic devaluing of cases involving gay men and men of color, a pattern embedded in investigative resource allocation rather than in any individual officer's decision. The original federal hate crime statute, passed as part of the Civil Rights Act of 1968, covered only race, religion, and national origin in crimes connected to federally protected activities. Sexual orientation was explicitly excluded during drafting due to political opposition, and that exclusion remained intact for 41 years. The Hate Crime Statistics Act of 1990 required the FBI to collect data on bias-motivated crimes, including those based on sexual orientation. But collecting data is categorically different from prosecuting crimes, and no federal sentencing enhancement existed for those cases, regardless of what the data showed. The Matthew Shepard and James Byrd Jr. Hate Crimes Prevention Act of 2009 expanded federal hate crime law to cover sexual orientation, gender identity, and disability, and critically removed the requirement that the crime be connected to a federally protected activity. A structural change that dramatically expanded prosecutorial reach in cases that previously could not be brought federally. During congressional debates over the act, advocates repeatedly cited documented cases of serial violence against gay men that had been systematically under-investigated, presenting the pattern as direct evidence that the absence of legal tools had operational consequences, measurable in body counts. A legal framework that could see a pattern of violence against a population, but had no formal mechanism to name it, track it, or prosecute it differently, wasn't blind. It was choosing what to look at. The law that changed, that took 41 years to arrive. 13. People assume life imprisonment without the possibility of parole has always been the obvious default for the most serious violent crimes. That the justice system has always understood that certain individuals should simply never be released. Life without parole was not a standard sentencing option in most American states before the 1970s and 80s. The push to formalize and expand it was driven directly by documented cases where killers and repeat violent offenders were released on parole and immediately murdered again. Kenneth McDuff was convicted of murdering 3 teenagers in Texas in 1966 and sentenced to death. His sentence was commuted to life when the Supreme Court temporarily halted executions in 1972. He was paroled in 1989 due to prison overcrowding and subsequently murdered at least 9 more people before being recaptured in 1992. The McDuff case was cited repeatedly in Texas legislative debates that produced major parole reform legislation and was used nationally to argue for formal life without parole sentencing as an alternative to death sentences that could be commuted through subsequent court decisions or administrative action. Before the 1970s, life sentences in many states carried automatic parole eligibility review after a fixed number of years. The assumption embedded in the law was that all offenders were potentially redeemable. Rehabilitation was the stated purpose of incarceration, and permanent imprisonment was philosophically inconsistent with that framework. The shift away from rehabilitation as the primary stated goal occurred legislatively through the 1970s and 80s, driven largely by high-profile cases of violent recidivism. Life without parole expansion was a direct expression of that philosophical shift, written into statute. The Supreme Court in Harmelin v. Michigan in 1991 upheld a mandatory life without parole sentence and established the constitutional framework under which it could be broadly imposed, clearing the way for expanded use in violent crime sentencing across the country. California's Three Strikes Law of 1994 passed with 70% of the popular vote in the same election cycle as a major federal crime bill, marketed explicitly using cases of repeat violent offenders who had cycled through parole. Recent Supreme Court decisions have restricted life without parole for juvenile offenders, reopening dozens of cases. Life without parole didn't emerge from a debate about justice theory. It emerged from a parole board decision that produced a second set of funerals, and the law that followed was named after the people at those funerals. 14. People trust that the autopsy process is uniform, scientifically rigorous, and reliable. That a medical examiner in any jurisdiction would identify the same findings, reach the same conclusions, and flag the same indicators that a death is not what it appears to be. Before federal guidelines and training standards were introduced in the 1980s and 90s, autopsy practices across the United States were wildly inconsistent, and in several documented serial killer cases, deaths that should have been classified as homicides were certified as accidents or natural causes, allowing killers to keep operating while cases were filed as closed. John Wayne Gacy buried 29 of his victims under and around his home over a period of years. During that time, multiple young men in the area had been reported missing, but the absence of bodies meant no autopsy flags and no mechanism to connect the disappearances. When the bodies were finally discovered, forensic anthropologists had to be brought in specifically because local pathology resources were insufficient for a mass recovery of that scale. Janine Jones, a pediatric nurse convicted of murdering children in her care in Texas, had multiple deaths initially attributed to natural causes before statistical analysis, not forensic examination, flagged the anomaly. Pattern recognition by an epidemiologist identified what the autopsies had missed. A 1978 report from the National Association of Medical Examiners identified that a significant percentage of American jurisdictions were still using elected lay coroners, people with no medical training, to certify causes of death in homicide investigations. In some rural counties, the coroner was the local funeral director, producing a conflict of interest that was recognized, documented, and not addressed for years. The movement to professionalize death investigation was accelerated by cases where investigators later determined that earlier deaths attributable to the same killer had been miscertified. Harold Shipman, a British general practitioner who murdered an estimated 215 to 250 patients over 23 years, signed his own victims' death certificates and certified each one as natural causes. The pattern was identified by a funeral director who noticed the death rate and mentioned it to a colleague, not by any forensic or regulatory system. Name standards for autopsy procedure were codified as a national benchmark through the 1990s, but remain voluntary. No federal law mandates that death investigations meet a uniform standard. The reforms that followed were not born from professional ambition. They were born from counting the cases where killers remained on the floor. 15. People believe that when police are hunting a suspected serial killer, they should be able to get into that person's home immediately and find the evidence, and that courts have always made that reasonably accessible when the stakes are high enough. The Fourth Amendment warrant requirements that complicate serial killer investigations were not designed to protect killers. They were strengthened in direct response to documented police practices, in which innocent people's homes were searched illegally, their property destroyed, and their lives upended based on suspicion that proved entirely unfounded. Frequently in the chaotic aftermath of high-profile violent crime investigations, where pressure to produce a suspect was enormous. The Supreme Court, ruling in Mapp v. Ohio in 1961, established the exclusionary rule that evidence obtained through illegal searches cannot be used at trial, because Dalry Mapp had her home searched without a valid warrant in a case unrelated to serial violence. The ruling immediately changed how violent crime investigations operated and has shaped them ever since. In the aftermath of the Boston Strangler investigation of 1962 to 1964, it was documented that Boston police conducted warrantless or improperly warranted searches of numerous apartments, targeting buildings where women lived alone. Multiple innocent men were also detained and subjected to intensive interrogation with no legal basis. Probable cause standards in homicide cases were directly tested in Illinois v. Gates in 1983, where the Supreme Court relaxed the definition of probable cause for warrant applications. A ruling law enforcement had sought, partly by citing the operational difficulty of establishing rigid probable cause in pattern crime investigations, where evidence was inherently circumstantial. The Green River Killer investigation in the 1980s involved extensive surveillance of innocent individuals who fit geographic or behavioral profiles, including contact that was later scrutinized for its legal basis. The investigation's eventual resolution, through DNA evidence, implicitly validated the legal constraints that had slowed more aggressive early approaches. Dennis Rader's identification through floppy disk metadata sidestepped many of the traditional search constraints, prompting academic and legal discussion about whether digital forensics operated in a different constitutional space than physical search. The warrant requirement that sometimes slows a serial killer investigation is the same warrant requirement that prevented police from searching your neighbor's apartment because he made them uncomfortable. The Constitution doesn't have a carve-out for "we're fairly certain," and the history of why not is full of people who were absolutely certain and absolutely wrong. 16. Most people carry a fixed picture of what a serial killer looks like. Socially invisible, clearly disturbed, isolated. The obvious monster who gives everyone around him the creeps before he's finally caught. This image is not only wrong, it is operationally dangerous, and the investigators who built the original profiling system documented its inaccuracy in their own notes, while simultaneously allowing it to calcify into training doctrine. Ted Bundy was enrolled in law school, worked a suicide prevention hotline, was described by colleagues as empathetic and personable, and maintained a long-term relationship with a partner who later described their time together as normal. His first confirmed murders occurred years before any suspicion was directed at him. John Wayne Gacy was a Democratic Party precinct captain, organized neighborhood community events, ran a successful construction business, and was photographed with the First Lady of the United States. He murdered 33 people. Neighbors described him as a good neighbor. Dennis Rader worked as a city compliance officer enforcing local ordinances in Wichita, while composing detailed letters to police about his murders. He was simultaneously serving as a church council president. His congregation reported his arrest as a source of genuine shock. The FBI's own crime classification manual, developed in the 1980s, includes detailed descriptions of organized offenders who maintain functional social lives, hold steady employment, are in relationships, and present no overt behavioral flags, directly contradicting the popular image. The psychological term for the capacity of psychopathic individuals to maintain convincing social presentation while committing serious violence is masking, a documented clinical phenomenon with significant implications for investigation, because the behavior that would flag the obvious creep stereotype is specifically absent in high-functioning presentations. Legislative responses to serial killer cases have repeatedly been structured around the stranger danger model. The assumption that predators are obviously abnormal and primarily target strangers. Research consistently shows this model is statistically inaccurate and that victims frequently have prior contact with their killers, a fact with significant implications for victim-centered investigation protocols that have been slow to update. Law enforcement trainers have cited the pop culture profile as an active operational hazard, noting that investigators who anchor on the obvious monster image systematically underweight evidence, pointing towards socially integrated suspects. The most dangerous profile in this history isn't the person who makes you uncomfortable. It's the one who brought food to the potluck. The law enforcement system learned this lesson repeatedly and periodically forgot it between cases. 17. People assume that when a sexual assault is reported and evidence is collected, that evidence enters a pipeline that moves urgently toward identification and prosecution, a seamless system protecting victims and creating consequences for offenders. At the peak of the documented backlog, an estimated 400,000 to 500,000 rape kits sat unprocessed in police storage facilities and crime labs across the United States. Some had been sitting for years, some for decades. In multiple documented cases, serial offenders who would later escalate to additional violence could have been identified and stopped through DNA matches that were never run because the kits were never tested. In Detroit, a 2009 audit of a police storage facility discovered over 11,000 untested kits. When Michigan eventually funded processing, the results identified 817 potential serial rapists. Individuals whose DNA appeared in multiple kits collected over multiple years across multiple victims. They had continued offending throughout the entire period. The kits sat in storage. The Violence Against Women Act of 1994 provided federal funding for kit processing, but established no mandatory processing timeline. Kits collected but not submitted were not illegal to store. They occupied an administrative gap where evidence was preserved but deliberately unused, and no law required that situation to change. Lavinia Masters, a survivor who was 13 when she was assaulted in Texas in 1995, discovered decades later that her kit had never been processed. The individual responsible for her assault had committed additional attacks during the years the kit sat untested. Her advocacy directly produced Texas legislation mandating processing timelines. Federal legislation mandating rape kit processing timelines was incorporated into the Justice for All Reauthorization Act. Explicitly framed around documented cases where delayed processing had allowed serial offenders to continue. In several cases where serial killers were eventually convicted, review of their prior criminal histories revealed earlier assault arrests in jurisdictions where kits had been collected but never tested. Had those profiles entered the DNA database when the kits were collected, subsequent victims might have been spared. As of the most recent reporting, all 50 states have enacted some form of rape kit processing legislation, but enforcement mechanisms and funding vary widely. The most powerful piece of criminal evidence ever developed was being stored in cardboard boxes in police warehouses while the people it could have identified were still active. The law that made processing mandatory arrived 30 years and hundreds of preventable assaults after the kits started stacking up. 18, people assume that serial killers operate chaotically and randomly, that the investigation must therefore cast the widest possible net and treat every lead with equal weight. Geographic profiling, the mathematical analysis of crime scene locations to predict where an offender lives or anchors socially, was developed specifically in response to investigations where the spatial pattern of murders was being systematically misread, causing investigators to concentrate resources in entirely the wrong areas, while killers continued operating in the areas they had been looking away from. Kim Rossmo, a Royal Canadian Mounted Police detective who earned a doctorate in criminology, developed the mathematical algorithm underlying geographic profiling in the late 1980s and early 90s. His initial presentations of the methodology to police command were met with institutional resistance. His system is based on the principle that serial offenders typically operate within a comfort zone anchored by their home or work location, and that crimes cluster at a predictable distance from where the offender actually lives, close enough to be accessible, far enough to provide psychological distance from their own front door. The Yorkshire Ripper investigation in the United Kingdom is the canonical case study in geographic misinterpretation. Police received communications from a man claiming to be the killer in a distinctive regional accent and heavily redirected resources toward that region. Peter Sutcliffe, who lived in Bradford, had been interviewed by police 9 times before his eventual arrest in Sheffield. Following the Yorkshire Ripper failure, which became the subject of official public inquiry, British law enforcement became among the first institutional adopters of geographic profiling, embedding it into major incident investigation protocols that later became statutory guidance for serious crime investigation. The Violent Crime Linkage Analysis System, Canada's adaptation of the American VICAP model, specifically incorporated geographic data fields influenced by Rossmo's research, a legislative and administrative product of the recognition that spatial data was being collected in investigations but never systematically analyzed. Geographic profiling has since been used in over 4,000 cases across dozens of countries. Its use is not mandated by statute in the United States, but it has been incorporated into FBI training and several state-level investigation protocols, following documented successes in high-profile cases. For most of criminal investigation history, police looked for serial killers where they found bodies. Geographic profiling made the obvious point that the body is where the killer stopped, not where he started. The laws and protocols that followed were an admission that the map had been upside down. 19. People assume a criminal record follows an offender universally. That once documented anywhere in America, their history is visible to any law enforcement agency that runs their name through any system. For most of American law enforcement history, criminal records were local documents. A conviction in one state did not automatically appear in another state's background check system. Interstate compact agreements and federal record-sharing mandates exist specifically because serial killers and repeat violent offenders exploited jurisdictional blindness as a deliberate operational strategy, moving to places where they were, effectively and legally, strangers. The National Crime Information Center, established by the FBI in 1967, was designed specifically to address the jurisdictional record-sharing gap. But participation was not mandatory for all categories of crime, and the data entered was only as complete as what individual agencies chose to submit. A record existed only to the extent that someone had entered it, and the decision about what to enter was discretionary. The Brady Handgun Violence Prevention Act of 1993, which created the National Instant Criminal Background Check System, was passed partly because documented cases of violent offenders, individuals with disqualifying records, had legally purchased firearms because their disqualifying history sat in a state system that didn't communicate with federal databases. The record existed. The connection didn't. The National Sex Offender Registry, created through the Wetterling Act and expanded by the Adam Walsh Child Protection and Safety Act of 2006, specifically addressed convicted sex offenders, some of whom had committed homicides, who moved to states where their records were not immediately accessible to local law enforcement, and who resumed normal community life under that cover. The Interstate Compact for the Supervision of Offenders on Probation and Parole was revised and modernized in 2002 specifically because high-profile cases demonstrated that paroled violent offenders were relocating and falling through supervision gaps in the handoff between state systems. Andrew Cunanan, who murdered 5 people including Gianni Versace in 1997, moved across multiple states during his killing progression. Post-investigation analysis noted that while he appeared on warrant databases, information sharing speed between jurisdictions during the active case was slower than the mobility of the subject. American law enforcement was, for decades, a collection of filing cabinets that didn't communicate with each other. A killer who knew this could move states and become, in practical terms, a different person. The laws that finally forced the cabinets to talk were written by people who'd spent years wondering how the same man kept disappearing. 20 people believe incarcerating a serial killer ends the danger, that the walls, the surveillance, the system make everyone inside safe, and that maximum security means maximum protection for everyone on both sides of the door. Documented killings inside maximum security federal and state prisons, committed by individuals already serving life sentences or awaiting execution, exposed a fundamental gap in sentencing logic. For someone who cannot receive a more severe punishment, conventional deterrence calculations are mathematically zero. The legislative and administrative responses created new classification systems, solitary confinement protocols, and architectural standards that remain legally controversial today. Carl Panzram, a serial killer and violent criminal, murdered a prison laundry worker named Robert Warnke at Leavenworth Federal Penitentiary in 1929. At the time of the murder, Panzram had already made explicit statements to prison staff that he intended to kill as many people as possible before his execution, and that the threat of life imprisonment meant nothing to him. His case contributed to early conceptual discussions of what would eventually become federal supermax classification. The opening of ADX Florence in Colorado in 1994, the most secure federal prison in the United States, was a direct administrative response to documented violence by already imprisoned violent offenders. The facility's architecture makes physical assault on staff and other prisoners nearly impossible through design rather than supervision, because supervision had already been demonstrated as insufficient. Multiple murders have been committed inside high-security facilities by individuals serving life sentences, prompting state legislative reviews of classification protocols and the housing conditions for violent lifers. The legal framework governing solitary confinement, a primary management tool for incarcerated individuals who have committed additional violence while imprisoned, has been subject to Eighth Amendment challenges, producing court-mandated minimum condition standards that now govern how the most dangerous incarcerated individuals are managed. Several states created separate mandatory consecutive sentences specifically for acts of violence committed during incarceration, addressing the legal question of how to sentence an act that occurs when the defendant is already at the maximum punishment level. Charles Manson directed murders from prison through communication with followers outside, contributing to regulations on mail, phone contact, and outside access for incarcerated individuals. A maximum security prison was designed to keep someone inside who doesn't want to be there. It was not designed around what happens when someone already has nothing left to lose. The architecture and regulations that address that question were written after the funerals. 21. People assume that securing a crime scene, keeping it untouched until forensic teams complete their documentation, has always been a legally mandated, universally enforced standard. Yellow tape, controlled access, evidence preservation. Formal crime scene preservation protocols did not exist as enforceable legal or regulatory standards in most American jurisdictions before the late 1970s and 80s. In several high-profile serial killer investigations, detectives, police administrators, media representatives, and public officials walked through active crime scenes before forensic documentation was completed, destroying evidence that could have identified killers years before they were eventually caught. The investigation of John Wayne Gacy's property in 1978, while ultimately productive, exposed serious problems with large-scale excavation evidence handling. The volume of evidence and the ad hoc nature of the recovery operation, conducted without a formalized protocol for mass casualty evidence recovery, because no such protocol widely existed, complicated the precise documentation required for individual victim identification in subsequent legal proceedings. Chain of custody requirements for evidence, the legal documentation showing who handled a piece of evidence, when, and under what conditions, were formalized in federal rules of criminal procedure and in state equivalents, partly because courts were excluding evidence in violent crime cases where the chain of custody was broken, undocumented, or contradicted by testimony. The Scientific Working Group for Bloodstain Pattern Analysis, the Forensic Working Group for Digital Evidence, and equivalent standards. Bodies were all formally established in the 1990s as regulatory and standard-setting entities, direct products of the recognition that crime scene evidence was being collected and analyzed without any enforceable professional standards governing how either process should be conducted. Federal grant programs through the Bureau of Justice Assistance now include funding specifically for crime scene investigation training and equipment standardization, a programmatic response to documented findings that evidence quality in violent crime cases varied enormously depending on the resources and training levels of the responding jurisdiction. Trace evidence collection standards, protocols for collecting hair, fiber, soil, and microscopic material were substantially developed following serial killer investigations, where trace evidence was the primary link between crime scenes. Wayne Williams's conviction in the Atlanta child murders relied heavily on fiber evidence, and the collection and analysis methodology used became a national training reference. For most of detective history, A murder scene was a place everyone walked into to look around and then argued about later. The law requiring someone to put tape around it and stay out was written after enough people realized they'd been trying to solve puzzles after stepping on half the pieces. 22. People believe hospitals are closely monitored environments where a suspicious pattern of patient deaths would be caught immediately. By other doctors, by administrators, by some regulatory body watching the data. Healthcare workers who murder patients have among the highest documented victim counts of any offender category, specifically because the institutional infrastructure of hospitals was built to absorb patient death as an expected outcome, not to detect it as a pattern requiring criminal investigation. Harold Shipman, a British general practitioner, murdered an estimated 215 to 250 of his own patients over a 23-year career before his arrest in 1998. Every death was certified by Shipman himself, classified as natural causes, and buried. The pattern was identified not through any clinical observation, medical review, or regulatory audit, but because a local funeral director noticed Shipman's patients were dying at an unusual rate and mentioned it to a colleague. The Shipman Inquiry, a public investigation ordered by the British government and concluded in 2005, produced 6 volumes of findings that directly generated major reforms to death certification processes, oversight of single physician practices, and monitoring of controlled substance prescribing, none of which had previously existed as enforceable regulatory standards with the capacity to detect a pattern like Shipman's. In the United States, Charles Cullen, a nurse who worked in 10 hospitals across New Jersey and Pennsylvania between 1988 and 2003, murdered an estimated 29 to 400 patients. He was fired or asked to resign from multiple facilities for behavior that raised concern, and each time he was quietly allowed to leave, hired by a new facility, and continued. No hospital reported his departure circumstances to state nursing boards. No law required them to. Following the Cullen case, New Jersey passed the first law in the United States requiring healthcare facilities to report to state boards when an employee was terminated or resigned under circumstances involving patient harm investigations. Before this law, voluntary non-disclosure was the standard industry practice. Drug enforcement oversight of controlled substance tracking in hospital settings, monitoring whether medications actually reached the patients they were documented as reaching, was substantially tightened following documented cases where healthcare killers sourced medications through diversion. Statistical surveillance systems designed to flag anomalous patient death rates were not standard practice in American hospitals before the documented cases of the 1990s and 2000s forced both regulatory recommendations and voluntary adoption. The institution built to care for sick people was simultaneously built to treat every death as a medical event, and none of them as a potential crime. The laws that changed that were not written by physicians. 23. People believe discovering a body automatically triggers a full criminal investigation, that the system responds uniformly and seriously to every death, regardless of who the victim is or where they were found. In documented serial killer cases, multiple victims' bodies were discovered and certified as natural deaths or accidents with minimal or no criminal investigation, a failure traceable to both resource gaps and the systematic devaluation of certain victim populations by the investigative institutions meant to serve them. Robert Picton, a farmer in British Columbia, murdered between 26 and 49 women over a period of years, while the community repeatedly reported missing women to police. A public inquiry concluded in 2012 that the Royal Canadian Mounted Police and Vancouver Police Department failed to adequately investigate the disappearances, with institutional bias contributing to the inadequate response. The missing and murdered Indigenous women crisis, documented across both Canada and the United States, represents the most extensively documented example of investigative failure organized around victim population. Canada's national inquiry into missing and murdered Indigenous women and girls, conducted from 2016 to 2019, produced 231 calls for justice. A comprehensive legislative agenda for reforming death investigation and missing persons response that acknowledged the failures weren't individual mistakes, but systemic outcomes. In the United States, Savannah's Act and the Not Invisible Act, both passed in 2020, addressed investigative failures, including the requirement that federal law enforcement develop protocols specifically for cases involving indigenous victims that had previously fallen through jurisdictional gaps between tribal, state, and federal authority. The Grim Sleeper case in Los Angeles, Lonnie Franklin Jr., who murdered at least 10 women in South Los Angeles between 1985 and 2007, was characterized by extended periods during which the case received minimal investigative attention. Community advocates, researchers, and journalists documented the correlation between resource allocation and victim demographics in ways that eventually influenced policy changes at the department level. The requirement that sudden, unexplained, or violent deaths be reported to a medical examiner is not uniformly applied across United States jurisdictions. In some rural counties, determining which deaths require official investigation remains discretionary, a gap forensic pathologists have identified as a documented risk factor in undetected serial homicide. The law has always said all lives have equal value. The investigative response said otherwise in allocation decisions and resource assignments for years. 24, people believe the death penalty specifically deters serial murder, that the existence of capital punishment prevents calculated, predatory offending because rational actors weigh consequences before acting. The research literature on capital punishment and serial murder, including direct recorded interviews with convicted killers, consistently indicates that the death penalty functions as a negligible deterrent for this specific offender category, primarily because serial killers either believe they won't be caught or operate in a psychological state where future consequences are effectively invisible. Multiple academic studies of convicted serial killers' cognitive patterns, including foundational work on psychopathy by researcher Robert Hare, demonstrate that psychopathic offenders systematically underestimate the probability of capture, a feature of their cognition that structurally disconnects them from standard deterrence logic. A consequence you are certain you will never face does not deter. FBI agent Robert Ressler's documented interviews with convicted killers, published in his account of the Behavioral Science Unit's work, record multiple offenders describing capital punishment as irrelevant to their pre-offense thinking. They had not believed they would be caught, and the existence of a maximum penalty had not entered their calculations. Ted Bundy stated directly in recorded interviews that the death penalty had no deterrent effect on him, and that the concept of consequences had been entirely abstract during the period he was committing offenses. He was subsequently executed in Florida in 1989, and his execution was cited in both pro and con arguments about deterrence in legislative debates that followed in multiple states. States with high rates of capital punishment have not demonstrated consistently lower rates of serial homicide. Studies examining homicide rates before and after death penalty abolition or reinstatement have generally failed to find a statistically significant deterrent effect, and several studies have identified a possible brutalizing effect operating in the opposite direction. Legislative debates over capital punishment in the serial murder context have repeatedly featured the argument that life without parole serves the incapacitation function without the constitutional complexity and documented error risk of capital cases. The Innocence Project has documented more than 185 death row exonerations, several involving crimes initially believed to be the work of a serial offender. The Supreme Court's removal of the death penalty for juvenile offenders in 2005 was informed partly by research on adolescent decision-making that recognized the deterrence assumption does not apply uniformly across cognitive profiles, logic that academics have applied to adult psychopathic offenders with no equivalent legal recognition. Capital punishment was sold partly as the ultimate answer to the ultimate crime. Then, someone asked the killers. Their answer is in the interview transcripts, filed in government archives, and it has not changed. 25. Most people believe the McDonald triad, the theory that bedwetting, fire setting, and cruelty to animals in childhood reliably predicts future violent offending, is established criminological science. It gets taught, repeated, and cited with confidence. The McDonald triad was proposed in 1963 by psychiatrist J.M. McDonald based on a study of 100 patients, a sample that was not representative, not replicated, and not constructed from actual convicted serial killers at all. Subsequent research consistently failed to validate it as a predictive tool. Despite this, it became embedded in criminal law, Child Protective Services protocols, juvenile justice policy, and law enforcement training for 30 years. McDonald's original paper proposed the triad based on comparing psychiatric patients who had made homicidal threats to non-threatening patients, not a study of people who had actually committed serial violence. The leap from expressed homicidal ideation to future serial homicide was entirely inferential, built into the study's design without acknowledgement. The triad was adopted and amplified by the FBI's Behavioral Science Unit in training materials through the 1970s and 80s, converting a contested psychiatric hypothesis into operational law enforcement doctrine. Once embedded in FBI training, it propagated into police departments, social services agencies, and courtrooms nationwide without ever undergoing the validation process that adoption at that scale required. Studies conducted in the 1990s and 2000s specifically testing the triad against databases of convicted violent offenders found no consistent predictive relationship. A comprehensive study from 2004 found that the three behaviors, individually and in combination, did not reliably predict adult violent criminality at rates beyond what would be expected by base rates in the general population. The triad's influence on child welfare law was direct and measurable. In multiple jurisdictions, children identified as exhibiting all three behaviors were placed into higher risk service categories and, in some cases, subjected to more aggressive juvenile justice handling. Legal consequences derived from a theory that subsequent research could not substantiate. Serial killers commonly cited as exemplifying the triad did not, when their documented childhood histories were examined, consistently exhibit all three behaviors in the pattern the theory predicted. The retrospective application was often speculative, drawing on sources of questionable reliability. American criminal law spent 30 years partly organized around a theory tested on 100 people and never replicated. The scientific correction was quiet. The policy correction is still incomplete. 26. Law enforcement and the public assume serial killers rigidly adhere to a specific victim type. That identifying the pattern makes the next victim predictable. That resources can be concentrated on protecting an identifiable group. And that the pattern itself is a stable investigative anchor. Multiple killers in the documented record deliberately varied their victim selection, either intentionally or as circumstances shifted, specifically because investigative resources were being concentrated on protecting a known type. The laws and protocols built around fixed victim profiling were repeatedly exposed as insufficient when killers adapted, producing reformed investigative guidance, acknowledging that victim pattern is a tool with hard limits. Randy Kraft, convicted of 16 murders in California with probable additional victims, targeted young men, many connected to military service. But his victim selection was driven by opportunity and geography as much as by any fixed psychological preference, a pattern that emerged only in retrospect and made real-time victim warning essentially impossible to implement effectively. Dean Corll, who murdered at least 28 boys in Houston between 1970 and 1973, operated in a city where missing persons reports were filed and largely dismissed because the victims were primarily from lower-income families in specific neighborhoods. The investigative assumption that missing teenage boys were runaways, not targets, was itself a form of pattern-based blindness that served as effective cover. The Atlanta child murders investigation was structured around a victim profile that was initially quite specific. When Wayne Williams was charged, the victims who didn't fit the profile were handled awkwardly by the investigation, a problem cited by scholars who continue to scrutinize whether all attributed cases were his work. The Yorkshire Ripper investigation was initially organized around a victim type that Peter Sutcliffe had already begun deviating from, before investigators updated their operational parameters. Several of his later victims, who did not match the initial profile, received less warning outreach than the group designated as at risk. VICAP's design includes flexible victim characterization fields, specifically because the second generation of serial crime analysis recognized that anchoring investigative resources on a fixed victim type created exploitable blind spots. The Violence Against Women Act's broadened funding mandates acknowledged that victim-type specific resources created protection gaps. Law enforcement training materials developed since 2000 increasingly emphasize offender behavior over victim type as the primary linking criterion, an evolution driven directly by documented failures of victim-centered pattern analysis. Building the warning system entirely around who the killer chose last week assumes the killer isn't watching the warning system. Several of them were. 27. People believe a confession is the most powerful evidence possible. That a serial killer confessing to a crime closes the case, confirms accuracy, and ends uncertainty. The serial killer confession record is one of the most legally entangled evidentiary bodies in American criminal justice. Henry Lee Lucas confessed to between 150 and 600 murders while in Texas custody in the early 1980s. Texas Rangers cleared over 200 cases based on his confessions. A formal Texas Attorney General review in 1986 found that the vast majority were either impossible to verify or demonstrably false, with Lucas providing details that had been supplied to him during interrogation sessions, rather than originating from his own independent knowledge. The Lucas case directly produced reforms in Texas confession protocol, specifically regarding documentation of how details were elicited to distinguish investigator-provided information from independently volunteered knowledge. A cleared case built on a contaminated confession is not a solved case. It is an unsolved murder with a name attached to it. In the Central Park 5 case of 1989, 5 teenagers confessed to the assault and rape of a jogger in New York City under intensive interrogation. They were later exonerated when Matias Reyes, an actual serial rapist who had committed additional attacks, confessed and was confirmed by DNA as the sole perpetrator. The case produced a landmark wrongful conviction review by the New York State Bar Association and contributed substantially to national debate about mandatory recording of interrogations. New York subsequently enacted legislation requiring electronic recording of custodial interrogations in murder cases, a direct legislative product of those exonerations. As of the most recent count, more than 25 states have enacted mandatory recording laws for custodial interrogations. The psychological mechanisms producing false confessions, including tactics in which investigators falsely tell suspects they have DNA or witness evidence when they do not, have been documented through laboratory research to produce false admissions even from demonstrably innocent subjects. Serial killer confessions have also produced the inverse problem. Killers whose confessions to actual crimes were ruled inadmissible, allowing known offenders to escape conviction on specific counts because the confession that identified them violated applicable constitutional standards. The reform most directly traceable to the serial killer false confession record is mandatory electronic documentation of homicide interrogations, a law that exists specifically because the unrecorded interrogation room had the highest documented rate of evidence contamination of any location in the investigation. 28. The serial killer in the public imagination is invariably male. The category is so thoroughly gendered in cultural representation that female serial killers are routinely treated as bizarre anomalies requiring special psychological explanation, rather than as offenders whose documented existence exposes significant gaps in the investigative and legal frameworks built around male offender assumptions. Female serial killers represent a minority of the documented population, but a substantial enough group, and a group different enough in method and victim selection that the frameworks built around male offender patterns systematically fail to detect them. Research catalogs by academics, including Eric Hickey, document that women have accounted for approximately 15% of identified serial killers in the United States, a figure that has remained relatively consistent across the 20th century. The methods used by female serial killers diverge significantly from the physical violence most associated with male offenders. Poison, suffocation, and medical intervention predominate, methods that produce deaths statistically less likely to be identified as homicide in initial examination because they are consistent with natural causes or accident. This is not coincidence. It is the method selection of someone operating in an environment where the expected explanation is already available. The healthcare serial killer category, which includes multiple documented cases across international jurisdictions, disproportionately involves female offenders, and the investigative failures in those cases are partly attributable to institutional resistance to conceptualizing women in caregiving roles as potential predators. Janine Jones, a pediatric nurse convicted of murdering children in her care in Texas in the early 1980s, was the subject of an internal hospital review before criminal referral. The review's reluctance to reach the conclusion a nurse was deliberately killing children contributed directly to the investigation's delay. Criminal profiling tools developed by the FBI were built primarily on male offender interview data. The 36-killer study included no women. The behavioral indicators embedded in FBI profiling training were calibrated against male offender patterns, creating systematic blind spots for female offender presentation. Sentencing research has consistently found that female defendants in violent crime cases receive more lenient outcomes than male defendants for equivalent offenses, a disparity attributed to embedded assumptions about female capacity for sustained violent intent. The investigative system built to catch serial killers was built by interviewing 36 men in prison. The 15% it was never designed for has been operating in care environments and domestic settings for decades. The gap has not closed. 29 people believe the FBI automatically assumes control of any serial killer investigation, that federal authority activates at some threshold of severity, and that a centralized federal response is the guaranteed outcome when the case is serious enough. The FBI has extremely limited statutory authority to investigate serial homicide in the absence of a specific federal nexus: interstate transport, federal property, specific civil rights violations, or crimes that cross particular legal thresholds. Serial killers who operated within a single state, even across multiple counties, were legally the exclusive responsibility of local and state agencies. Several killers were documented as being aware of this structure, and several investigations identified the absence of federal involvement as a contributing factor in extended operating periods. John Wayne Gacy operated entirely within Cook County, Illinois. Despite the scale of his crimes, the FBI had no statutory basis to take operational control. The discovery and prosecution were entirely an Illinois matter, conducted by local and county law enforcement with limited federal support. The Bureau's role was advisory, not directive, because the law made it so. The analysis that led to the development of VICAP found that multiple serial killers had operated for extended periods in single states, specifically because no national investigative resources were automatically deployed in their absence. A finding that accelerated both the VICAP legislation and voluntary information sharing agreements between the FBI and state law enforcement agencies. The Violence Against Women Act and subsequent federal legislation providing grants for violent crime investigation, deliberately avoided the jurisdictional question by providing funding and training rather than direct investigative authority, a mechanism for federal involvement that respected constitutional limits on federal jurisdiction over intrastate crime. Multiple serial killers have been identified in retrospective analysis as having been aware of jurisdictional structures. The BTK killer operated in Wichita for decades, and his crimes were the exclusive jurisdiction of the Wichita Police Department and Sedgwick County authorities. Federal involvement was requested, not automatic. The FBI's behavioral science unit's role in most serial killer cases has been advisory, profiling support and investigative consultation at the request of local agencies with no authority to direct operations or compel information sharing absent the federal nexus requirement. Recent legislation, including tribal jurisdiction provisions in the Violence Against Women Reauthorization Act, has expanded federal investigative authority in specific categories of serial violent crime. The most powerful federal law enforcement agency in the world was legally required to advise from the sideline in some of the worst homicide investigations in American history. The laws that gave them more tools were written by people who had spent years answering the question of who was in charge with. Technically, no one who can compel anything. 30. People believe modern DNA technology has made serial killing a practically unviable enterprise. That the forensic infrastructure is comprehensive enough that operating undetected over any extended period is simply no longer possible. DNA technology capable of identifying serial killers has existed since the mid-1980s. Multiple killers whose crimes were committed entirely within the DNA era continued operating for years or decades because laws governing collection, database entry, mandatory testing, and evidence preservation either didn't exist, weren't enforced, or hadn't been extended to the categories of evidence that would have produced the identifying match. DNA fingerprinting was developed by Alec Jeffreys in the United Kingdom in 1984. The first criminal conviction using DNA evidence occurred in Britain in 1988. Gary Ridgway committed murders throughout the 1980s and early 90s, the entire DNA era, and wasn't connected to the evidence until a 1987 sample was matched in 2001, 14 years after collection. The technology to run the match existed throughout that window. The legal mandate forcing anyone to run the comparison as new arrestees entered the system did not. CODIS launched in 1990 with profiles from convicted offenders, but did not initially require that all arrestees be entered. The database expanded through a series of legal amendments over subsequent decades, with the most significant expansion coming through the DNA Fingerprint Act of 2005, which authorized collection from all persons arrested for federal crimes and created incentives for states to collect from arrestees rather than waiting for conviction. The Golden State Killer, Joseph James DeAngelo, committed his crimes in the 1970s and 80s and was identified in 2018 through genetic genealogy, a technique using consumer DNA databases that existed in a complete legal gray zone. No statute authorized the method. No statute prohibited it. Congress held hearings that produced proposed legislation directly addressing this gap, citing the DeAngelo case, and a federal regulatory framework governing investigative use of genealogical databases still does not exist as enacted law. Cold case legislation enacted across multiple states in the 2000s and 2010s addresses the backlog of unsolved violent crimes where biological evidence exists but has never been tested against current databases. Researchers estimate hundreds of thousands of unsolved violent crimes have biological evidence sitting untested. Cases solvable with existing technology, waiting for the legal mandate that would force the sample to be run. The technology didn't catch the killers. The law that finally required anyone to use it did. 31. People believe the accumulated weight of decades of legislation, forensic reform, database development, and investigative protocol means the system is now fundamentally adequate. that the obvious gaps have been identified and addressed, and that the architecture of serial killer law is essentially complete. Every law in the preceding 30 items was written in the past tense. After the funeral, after the investigation, after the gap had already been demonstrated through a body of evidence that required months or years to assemble and catalog, the current legal architecture has known, documented, unfilled gaps, and the framework has never once anticipated the method, technology, or operational strategy that the next offender would use. Genetic genealogy, which identified the Golden State Killer, remains without federal statutory authorization or prohibition as of the most recent legislative session. The Department of Justice issued interim administrative guidelines in 2019, but administrative policy is not statute and changes with administrations. Encrypted communication platforms and dark web infrastructure present the same category of investigative challenge that email presented in the early 1990s. The law hasn't caught up to the technology, and the gap between warrant process and communication speed continues to widen. The medical serial killer category remains the least developed in terms of legal detection infrastructure, precisely because the setting produces expected deaths, and the institution is designed to absorb them. The missing and murdered Indigenous women crisis has identified structural causes, jurisdictional gaps, resource disparities, data collection failures that are documented in federal reports, acknowledged in enacted legislation, and not yet fully addressed by that legislation. The rape kit backlog, despite significant legal progress, has not been eliminated. New audits of previously uninventoried storage facilities continue to revise the estimated remaining untested kit count upward, meaning the scope of the problem was itself unknown. Artificial intelligence tools being deployed in serial crime investigation contexts, facial recognition, pattern analytics, behavioral flagging, are being adopted without the legal framework governing their accuracy standards, evidentiary status, or required validation that governed earlier forensic techniques. The academic literature continues to identify demographic categories of victims for whom investigative response is documentably slower, less resourced, and less legally protected. Populations that represent ongoing structural opportunity for offenders who select targets based on the predictable inadequacy of what follows. Every single item on this list began the same way, with a gap that someone identified only after the gap had been used. That's not a design flaw someone failed to catch. That's the operating principle. The next gap is already open. Someone is already in it. If you want to see more, click the video on screen now